हेलो एवरीवन, वेलकम टू योर सेकंड वीडियो ऑन द चैनल लॉपीडिया। आज के हम अपनी इस वीडियो में समझेंगे आर्टिकल 15, उसके क्लॉजेस, some of the relevant case laws and उसका basic concept. So as suggested, I've tried recording this particular video bilingually, that is both in English as well as in Hindi. Please do let me know in the comment section down below आपको ये particular format कैसा लगा, and let's just quickly start into the video and please stay tuned till the end of the video because we're going to be revising all the clauses of Article 15 in a holistic manner. Let's get started with the video. So we'll be starting with Article 15 and these are the broad grounds provided on which discrimination is prohibited. So your Article 15 reads as Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. So जब आप Article 15 पढ़ेंगे, you will realize that the article is divided into 6 clauses. In this particular slide, we'll be taking up clause 1, 2 and some of the basics of the Article 15. Now, if you go and read Article 15 clause 1, it talks about that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. So, यहाँ पे you need to focus on the words citizen as well as only. Now, your clause 2 talks about no citizen on grounds only of religion, race, caste, sex or place of birth or any of them be subject to disability, liability, restrictions or condition with regard to the access and use. So basically in your clause 2 of Article 15, Constitution states that कि कोई भी citizen on our 5 grounds, that is religion, race, caste, sex or place of birth के ऊपर कोई भी disability, liability, restriction या condition नहीं लगा दी जाएगी with regard to the access and use of certain things. The access to shops, public restaurants, hotels and places of public entertainment or the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of the state funds or dedicated to the use of general public. So I hope आपको basically समझ आ गया है कि clause 1 and clause 2 क्या हैं of our Article 15. So as you highlighted the term only, one may ask what is the significance of the term? Basically, when our constitution makers use the term only, they wanted to signify that Constitution exclusively prohibits discrimination only on the grounds of religion, race, caste, sex, place of birth or any of them. इसका मतलब ये है कि अगर आप कोई ऐसी डिस्क्रिमिनेशन कर रहे हैं जिसमें रिलीजन, रेस, कास्ट, सेक्स या प्लेस ऑफ बर्थ एक सोल क्राइटेरिया माना जाएगा या एक सोल ग्राउंड बनता है, ये डिस्क्रिमिनेशन कॉन्स्टिट्यूशन प्रोहिबिट करेगा अंडर क्लॉज 1. बट in case you're discriminating on this ground plus the other considerations, then the court will see what is the holistic aim of the act and then will decide. But you may ask what happens in case of discrimination on other grounds. So अगर आप दूसरे grounds पे discrimination करते हैं and you are not able to prove a valid reason for that, that will become a arbitrary discrimination and that will come under your Article 14. So I hope आपको clause 1 and 2 clear है. Also, it's another important point that you must note over here is Article 15 clause 1 covers only Indian citizens and does not apply to non-citizens. Apart from that, जब आप Article 15 और 16 पढ़ेंगे आपको ये पता लगेगा कि उसके बहुत सारे clauses mere enabling provisions है. What do I mean by when I'm saying they're mere enabling provision? It means there is no constitutional duty or there is no constitutional obligation for the state to abide by it. ऐसा कोई ड्यूटी नहीं है कि आपको वो प्रोवाइड करने ही है, बट येस स्टेट हैज बीन गिवन दैट फ्लेक्सिबिलिटी कि वो प्रोविजंस बना सकते हैं. डोंट वरी, वील इलैबोरेट ऑन दिस पर्टिकुलर कंसेप्ट फर्दर. सो इस स्लाइड का बेसिक एम यही था कि यू अंडरस्टैंड क्लॉज 1, क्लॉज 2 एंड उसके एम्बिट. नाउ अब नेक्स्ट आते हैं आपके एक्सेप्शंस टू द जनरल रूल पे. एक्सेप्शन 1 है 15 क्लॉज 3 में, जो कि स्टेट को ये पावर देता है कि इट कैन मेक स्पेशल प्रोविजंस फॉर विमेन एंड चिल्ड्रन फॉर देयर ओवरऑल अपलिफ्टमेंट इन सोसाइटी. सच स्पेशल प्रोविजंस मेड एक्सक्लूसिवली फॉर विमेन have been carved out as a permissible departure from Article 15(1). Why? Because we want their overall upliftment in the society. Now, your clause 4 talks about special provisions for socially and educationally backward classes of citizens or for scheduled castes and scheduled tribes. Please do remember that these are mere enabling provisions. That means they are not a constitutional obligation or duty, and state may or may not make such provisions. So, clause 3 talks about special provisions for women. Clause 4 talks about advancement of socially and educationally backward classes of citizens of a scheduled caste and scheduled tribes. Now, what does clause 5 talks about? Clause 5 talks about special provisions with regard to the advancement of socially and educationally backward classes or scheduled castes or scheduled tribes regarding their admission to educational institutions, including private educational institutions, aided or unaided, other than minority educational institutions referred to in clause 1 of Article 30. So, अब आपका क्लॉज 5 किस पे फोकस करता है? It focuses on the admission to educational institutions so that the backward classes are also incorporated in our educational system and that leads to their overall upliftment. So I hope आपको clauses 3, 4 and 5 clear हैं और इनके differentiating factors भी clear हैं. So now certain judicial interpretations. In the case of Government of Andhra Pradesh versus PP Vijay Kumar, the court stated Article 15 Clause 3 carves out a permissible departure from Article 15 Clause 1. I've already explained this particular point while explaining you the special provisions for women and children. So, if we ask a question that what does the expression special provision for women mean? It means or it may include all those activities which state may undertake to improve women's participation in various activities. Next point is 15 clause 4 confers discretion and does not create any constitutional duty or obligation. I have explained this point that these are mere enabling provision. They do not create any constitutional duty, but state अपनी discretion पे provisions बना सकते हैं या नहीं बना सकते. Another important case when you're reading Article 15, you need to notice Indira Sahni versus Union of India. In this particular case, Supreme Court ने ये कहा था कि Article 15 Clause 4 का ambit Article 16 Clause 4 से बहुत ज़्यादा है. Because Clause 4 confers several kinds of positive actions and plans that can be implemented in it, whereas Section 16 Clause 4 speaks of only one type of remedial measure, namely reservation of appointments or posts. Another important case you have to read when you're reading Article 15 is Balaji versus State of Mysore. इस केस में basically order issued by the State of Mysore को challenge किया गया था, which reserved seats for backward and more backward classes. Supreme Court ने ये कहा कि order was bad in law because it was solely based on caste and it had vague classification in terms of backward and more backward classes. Also, Supreme Court ने एक बहुत important point यहाँ पे note करवाया था कि caste as a sole criteria for determining social and educational backwardness is not correct. Court also stated that reservation needs to be reasonable and should not nullify our main provision or clause 1. Supreme Court also said that the order holistically provided 68% reservation, which is against the principles of Article 15 Clause 4. So 50% limit on reservation की बात कोर्ट ने करी थी बालाजी वर्सेस स्टेट ऑफ मैसूर केस में. So I hope आपको इस स्लाइड से certain exceptions clear हैं. We spoke about 15 clause 3, we spoke about 15 clause 4 and 15 clause 5, certain judicial interpretation and case laws. Now let's move on to 15 clause 6. So the clause 6 to the Article 15 was inserted in the Constitution by 103rd Amendment Act 2019. So ये काफी recent edition है and it provides for reservation for the advancement of economically weaker sections. Now if you read the article, it states that nothing in this article or subclause G of clause 1 of Article 19 or clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of economically weaker sections of citizens other than the classes mentioned in 4 and 5. So basically your clause 6 provides for additional reservations for the advancement of economically weaker sections. So जब हम economically weaker sections के बारे में बात करते हैं, the constitution states that it is other than the clauses mentioned in clause 4 and 5. So in clause 4 and 5 of article 15, we spoke about three classes itself, that is the socially and educationally backward classes, scheduled caste and scheduled tribes. Apart from that, the constitution has further provided reservation for the economically weaker section under clause 6 of article 15. Another aspect of clause 6 states that state can make special provision for economically weaker section of citizens other than classes mentioned in clause 4 and 5 insofar as such special provision relate to their admission to educational institutions including private educational institutions whether aided or unaided by the state other than the minority educational institutions referred to in clause 1 of article 30 in addition to the existing reservations subject to maximum 10%. So अब as per the clause 6 state को ये भी power दी गई है कि वो economically weaker sections of citizens के लिए special provisions बना सके ताकि उनका admission हो सके educational institutions के लिए and this will include private educational institutions whether aided or unaided, but इस provision से भी हमने minority educational institutions को exclude किया है that are specified in your clause 1 article 30. और ये जो reservation constitution provide करवाता है economically weaker section को, this will be in addition to the existing reservation and there is a maximum limit that has been provided by the clause which is 10%. तो 10% तक reservation आप economically weaker section of citizens को दे सकते हैं in their admission to educational institutions as per the clause 6. So I hope आपको clause 6 भी properly clear है. Apart from that, the clause 6 also fulfills the mandate of article 46 of the directive principle of state policy. Now, if you read article 46, it talks about promotion of educational and economic interest of scheduled castes, scheduled tribes and other weaker section. So ये जो particular clause 6 है, ये हमारा directive principle का mandate भी fulfill करता है. That is providing education to the other weaker sections as well. However, the addition of clause 6 came with various criticisms as well. Like, ये additional reservation आपकी 50% max ceiling limit को violate करती है. Secondly, insertion of clause 6 makes economic criteria as the sole basis of reservation. Often cases में Supreme Court has elaborately stated that economic factor cannot be made the sole criteria of reservation. But if you read clause 6, it expressly states that economically weaker sections. Now, एक criticism ये भी आता है clause का कि the term economically weaker section has not been properly defined. If you read the explanation of clause 6, it states that for the purpose of this article and article 16, economically weaker section shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. So, आपका ये economically weaker sections properly defined भी नहीं है. अभी तक we have covered all the clauses of your article 15. Now, we need to supplement them with the case laws. So, certain important cases. First is the state of Madras versus Champakam Dorai Rajan 1951. So, इस case में basically क्या हुआ था? The communal government order which pertains to the admission to medical and engineering colleges in Madras को challenge किया गया था. As जो ये particular order था, ये fix करता था proportionate seats for different communities. And ये जो order था, it treated caste as the sole basis for reservation. And Supreme Court expressly struck down this particular government order. So after this particular case, आपकी first constitutional amendment से add हुआ clause 4 जो कि अभी हमने discuss किया, talks about making special provisions for the advancement of socially and educationally backward classes of citizens or for scheduled caste and scheduled tribes. The second important case that you must read is Balaji versus State of Mysore. It again talks about a reservation order issued by the Mysore government, which treated caste as a sole criteria for discrimination, and Supreme Court ने इस particular case में ये state किया था कि caste एक sole criteria नहीं हो सकती for determining the social and educational backwardness. आपको other criteria भी देखनी है, and the reservation has to be reasonable and should not nullify clause 1 of Article 15. And court ने introduce करी 50% limit on reservation for such classes. The next important case that you can read is Ashok Kumar Thakur versus Union of India. So this particular case relates to your 93rd Constitutional Amendment Act 2005, जो की बात करता है Article 15 Clause 5 की. So in this particular case, Supreme Court examined the constitutional validity of Article 15 Clause 5. And certain questions जो इस केस में सुप्रीम कोर्ट ने रेज किए थे वो थे कि whether 93rd Amendment Act is against the basic structure, whether Article 15 Clause 4 and Article 15 Clause 5 are mutually contradictory, and whether exclusion of minority from Article 15(5) is a violation of Article 14. So this particular case deals with Article 15 Clause 5. Now another important case will be D.P. Joshi versus the state of Madhya Bharat. So इस particular case में court distinguished between place of birth versus place of residence as a factor of discrimination. So if you read clause 1 prohibit करता है discrimination only on the basis of place of birth and not place of residence. So this case basically deals with where the place of residence can be a factor of discrimination under your clause 1. Now the last that I have mentioned over here is Navtej Johar versus Union of India. It talks about the interpretation of clause 1. So clause 1 में हम 5 grounds पे prohibit करते हैं discrimination: religion, race, caste, sex, place of birth. So इस particular case में Supreme Court ने क्या ऑब्जर्व किया? सो इस पर्टिकुलर केस में सुप्रीम कोर्ट ऑब्जर्व दैट व्हेन वी आर टॉकिंग अबाउट इंटरप्रेटिंग आर्टिकल 15 क्लॉज 1 नॉन डिस्क्रिमिनेशन ऑन द ग्राउंड ऑफ सेक्स, it may include sex and other factors as well. Now what are the other factors associated with that? That is the marital status, age or pregnancy. So this particular case dealt with decriminalization of consensual sexual activity between the same sex relations. सो इस केस में बेसिकली उन्होंने ये कहा था कि अगर हम नैरो इंटरप्रिटेशन देंगे 15 क्लॉज 1 को, सो ये डिस्क्रिमिनेट नहीं करता, बट ऐसी नैरो इंटरप्रिटेशन वी कैन नॉट गिव. सो लॉज लाइक सेक्शन 377 इन सो फार as it criminalizes the activities between the consensual activities between same sex is a violation of Article 15 Clause 1. So the next slide is your revise, repeat and remember. So अब basically आपने सारे clauses Article 15 के पढ़ ली हैं. Now let us recall together what can you remember from each clause. Clause 1 basically talked about state shall not discriminate against any citizens on 5 grounds: religion, race, caste, sex and place of birth, or any of them. Clause 2 क्या बताता है? Clause 2 बताता है कि you will not impose any disability, liability or restriction on the citizen on the basis of these 5 grounds with respect to the access or use. Clause 3 क्या specify करता है कि state special provisions बना सकता है women और children के लिए. Clause 4 बात करता है कि state can formulate special provision for the advancement of socially and educationally backward classes, scheduled caste and scheduled tribes. Clause 5 majorly talked about कि state ऐसे provisions बना सकता है which relate to their admission to educational institutions. Clause 6 किससे डील करता है? Clause 6 deals with your economically weaker sections and जो provisions constitution ने recent amendment में उनके लिए बना है. And that's it primarily what we are covering in Article 15. As I've stated, I will mention additional cases that you can read with respect to the article in the description box below. So that was Article 15 for you. I hope आपको Article 15 holistically clear है. And इसके next video में we'll be covering Article 16. So also I would request you to read the comment section down below as a platform for discussion. So कोई भी ऐसा new case है जो आपने Article 15 के regarding पढ़ा है, do write them in the comment section down below for others to read as well. Apart from that, if you like this particular video, do click the thumbs up button and do subscribe, because I plan to come up with new video every Tuesday and every Saturday. Till then, stay home, stay safe and keep learning.